Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Let's go to Texas, because who doesn't want to be in Texas?
My good friends down there in Austin. I'm glad this decision's finally been handed down.
Yeah, and I got to tell you again, just like I said with the first case to all our viewers, this is not limited. Let me start with explaining what really the issue is. I'm going to imagine most, if not every state, there is something called, at least in New York State, I'll use the phrase, but it's the anti-gift prohibition. And what this says is, and this is true federally, this is true, I got to imagine in every state, even New Orleans, Louisiana, probably have something similar. They're a different code in any event. But what it says is you cannot use municipal monies as a gift. So, for example, in many states, including New York and many others, you cannot give bonuses to employees because it's a gift of municipal monies, right? You can't pay somebody for something they don't deserve. And so here, what was argued as against the union, but the union won here. So a group of taxpayers effectively tried to argue that granting the union officials, and this is extremely common, so this is a big deal across the nation, that granting union officials paid time off is a gift of municipal monies. And let me really summarize this case very easily, because I think I could do that. So here, the entire focus is this a gift of money where you didn't earn it, you didn't do anything to earn it, there's no benefit, it's just a pure gift? Or was this a bargained exchange where I'm giving you money or I'm giving you time off, but we got something in exchange? And the court very correctly, I think, who am I to say they're not, but very correctly, the court says, you know what, the municipality got a lot in exchange for giving this time off. For example, the court said, these union officials go to training, they go to meetings, they go to negotiations, and the municipality gets a lot from that, right? They may get favorable terms. They may get other things in exchange. So in short, they argued that this is not a gift of money. The municipality is getting something in exchange. We can get very specific. I don't know how specific you want to get, but that's really what it is.
Yeah, and one concern I have about this case is the Texas Supreme Court has shown a willingness to really be anti-employee and anti-collective bargaining. And that's one concern I have, is if this case were to be appealed to the Texas Supreme Court, would the court take because I think this is a pretty enlightened decision. I think that it was a thoughtful decision. It was a right decision. But I also think, based on the facts, that somebody who comes from a position of being anti-employee could say, "Yep, this is another example of something that's bad, and we're going to put a stop to it." And I hope that if it goes to the next level, it won't go in that direction. But I know this Texas Supreme Court was the court that said that firefighters don't have a Weingarten right. That a firefighter that's member of a union that has collective bargaining, that is called in for questioning, does not have a right to have a union rep there. What's the point of having a union and having representation if, when you're in trouble, you can't use them? Again, that's what concerns me, that sort of anti-employee mindset.
Yeah, and we'll see who's right. I'm not concerned, but for this reason. I'm not concerned because, generally speaking, appeal courts will not review the findings of, now this is generally, not always, right? In one case they just did review the factual findings, but generally the appeal courts accept the factual determinations of the trial court. Now, it's questionable whether these facts are facts that would be accepted or not. But if the appeals court, if it's appealed, and which it's going to be, of course, if the appeals court accepts the fact that the city got some things of value, right, in consideration of giving these concessions, et cetera, and giving this time, then I think the court has no choice as a matter of law to say, well, then it doesn't violate the anti-gift provisions. I'm more fearful of the court, if I was going to take your side in this, I would say I'm more fearful of the court saying, we just don't think that it's so conclusive that they're really getting something in terms, right? And that you're just giving time off for no reason. I don't know. The court got the right rule. So hopefully
I think they did. I really do. But I just I don't know what, just past cases that I've read from the Texas Supreme Court have not been overly employee friendly.
Yeah, the Weingart one's head scratching, but
yeah.
Okay, so but again, if this goes the other way, you are going to see cases throughout the nation challenging this.
Yeah,
it's a very common, right? It's extremely common. I just anyway, the court got it right, so I'm not going to complain yet.